So, welcome again to the Real Estate Junkies. Tonight, we're going to be talking about forms of title. It is like blah, 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 blah. Now, I said something really smart, and that is what pretty much people think when they think about title. If you don't know what title is and what way you can form the title, you're in a lot of trouble. Today, to help us out, is my buddy, Rami Romanian, an attorney that will help us understand forms of title. Rami, how you doing?
Great, Nick. How are you doing?
Good.
Good.
So, there is all kinds of forms of title, right?
Right. And as you so aptly stated, the way you take title to your property can have a lot of implications, from taxes to transferability.
Absolutely. Now, where do we start? So let's maybe start with the definition of title.
Sure.
And see how that would pan out into these different forms of title.
Okay. Well, when I talk about form of title, what I'm referring to is what's written on the deed to your house, the way you take title to your house. So if, for example, you and I were investing in property together, the deed for that property might say this property is owned by Rami and Nick as joint tenants.
Right.
You know, that's kind of what we're talking about.
And that's again in the form of looking at a regular home transaction. Everybody wants to have a clean title,
right?
Which means that everything on that document is written and there is nothing pending or no red flags on it.
Correct.
All
and
right.
so not only the syntax of the title, not only is that important, but also the way you take title. So I'll give you an example. If you have a married couple or you have a couple that's in a registered domestic partnership, they might take title as community property.
Now, registered domestic partnership, that was another word that just came up. Anything specific about that definition?
Well, no. Under California law, people that are in registered domestic partnerships receive the same rights and benefits as married couples, heterosexual couples.
See, that's good to know.
It's good to know,
now
right?
We can
Absolutely,
move on.
absolutely. So, essentially, when you take title as community property with somebody else, either your spouse or domestic partner, both parties have an equal stake in that property.
Right.
In California, anything that you acquire during marriage or during a domestic partnership that was purchased using community funds, that means using money that you earned during marriage or money that your spouse or domestic partner earned, that's considered community property.
Okay.
Both parties own it, and both parties would have a claim to that property if something were to happen, if they were to get divorced or separated.
Right, and that is particularly speaking now for the state of California.
Correct.
As a community property state.
Correct.
Okay.
Correct. Now that's different than if you were to take title as your sole and separate property. So to get back onto the community property, if you and your wife were to buy property together, it might say Nick, and I don't know your wife's name. Nick and your wife.
You'll meet Jasmina one day.
Okay, Jasmina. That's a beautiful name. Yeah. So it would say Nick and Jasmina as husband and wife as community property. That would be what would be written on the deed.
Okay.
And then that would create this type of co-ownership. Now, if you wanted to buy this property as your own sole and separate property, then title would look different. Your wife's name wouldn't appear on the deed. You would purchase it, it would say Nick Zigic, a married man, as his sole and separate property.
Now, that is a good point you make, because I didn't think of it at all until you brought it up.
Okay.
But there is an option of owning property within, when you're married, when you have a community ownership already established, to buy a property that would be only yours. Now, as far as the practice, is it a popular practice? Do people attend to that? And when do they choose to do that?
Well, people do it all the time, and they do it for a variety of reasons. In some cases, you might have a married couple where they have a prenuptial agreement and they've just decided to divide their assets in a certain way. Husband or wife will say, I'll purchase this property, it'll be mine, that property will be yours, and they'll separate their ownership in that way. They'll execute new deeds to divide the property.
All right.
In other cases, people might do it for asset protection reasons. People might have blended families, and they want property in their sole and separate name in order to provide for their other set of children. There's a whole host of reasons.
It's a great
for doing
thing.
that.
I think that everybody that has any thoughts about it should definitely look into it. and talk to their, I assume, attorneys, right?
Right, absolutely.
About it.
Before you make any decisions on how to form title, it's always good to consult with an attorney or
Right.
with some other professional who knows and is able to advise on these particular
That's
issues.
good. That's a good option. Now, what's others?
Well, community property isn't the only way to own property between two people. As you know, there's something called joint tenancy. Okay, joint tenancy is a very popular form of co-ownership, and it's not restricted to just married couples or people in domestic partnerships. So let's say you and I decide to invest in property together.
Okay.
We can buy the house or the building, and we can take title as joint tenants.
All right.
Now, what that does is it creates what's called a right of survivorship.
Okay.
Okay, the right of survivorship means if something were
We
to
do have to live in that property. We're talking about a property that we move in?
Not necessarily.
No? Okay.
No, you can own it. You can own it and use it for investment purposes. But the form of title as joint tenancy with right of survivorship means that if something were to happen to me, if I were to die, you would absorb my half of the property. That means then you would become 100% owner of the property because I'm no longer around.
Does that have tax consequences, by the way?
It does. It has some tax consequences, but I think the more important effect is, let's say in our same scenario, we bought this property together as joint tenants. Let's say you have a will, I have a will.
Right.
You, in your will, say, I give my half of the property to my kids, and I do the same. Because we took title as joint tenants, the effects of the wills are nullified.
Okay.
Meaning the joint tenancy overrides what's in the will.
Okay. So it's really a solid way of keeping that ownership within the parties that signed it in the first place.
Right.
Okay, cool.
In that sense, it's solid, but in another sense, it prevents you from being able to give the property to your loved ones after you pass away.
Right, so it depends on what your goal is.
What your goals are.
Okay, yeah, cool.
Right.
Next?
Next, well, another very common form of co-ownership is what's called a tenancy in common. Tenancy in common is basically when two people buy property, they each take an undivided fractional interest in the property. So let's say you and I buy the same property as tenants in common this time instead of joint tenants. Right. Literally what it would say on the deed would be that Nick would be owner as to 1/2, Rami would be owner as to 1/2 as tenants in common.
Right.
Meaning if something were to happen to you, your half can still pass via your will to your loved ones, and same with mine.
There was these large buildings with a couple hundred apartments in it that were all sold as a tenant in common properties. And the rules of the game were strict, so there was no way of reselling that piece of property unless certain conditions were met, which were hard to meet. So the buyers got stuck with the property that depreciated in value and couldn't be sold because of the rules of the common tenant in common agreement. Did you ever find any situations like that?
Well, the most common way to handle a transaction like that, where you have many different owners,
Right.
is to put the property into either a corporation or an LLC. And usually when you do that, you can impose all sorts of extra conditions upon all of the owners. So the way that would work is, again, using the scenario of you and I, let's
Right.
say we would like to invest in this building right here,
All right.
okay? It's a pretty nice building,
Top floor.
it looks good
Okay.
to me, let's buy it, okay? The most common way to do it is we'd form a corporation or an LLC.
Okay.
We go to the Secretary of State, file the necessary paperwork. Once we have the entity in place, you and I would each become shareholders in that company. So if it's a corporation, we'd be shareholders. If it were an LLC, we would be members. We would hammer out an agreement between you and I that has all the details of how we're going to rent the place out, what happens if one of us dies, what happens if one of us wants to sell and doesn't want to be a part of it anymore. And then we would acquire the property under the LLC.
Okay.
So the LLC would be the owner of the property and not us as individual tenants in common.
That's exactly how these projects were structured. So everybody would come in as a partner under that corporation, and agreement, the management agreement, or the
Well, if you have a corporation,
Right.
the document that governs your operations would be the bylaws. And if you have an LLC, which is a lot more flexible than a corporation, you would have what's called an operating agreement.
So the operating agreement is actually the one that everybody should read carefully.
Absolutely.
All
Everyone definitely, any contract that you enter into, you should read carefully and you should consult with appropriate legal counsel before
I
you
assume
sign.
that is the good advice.
Right.
Consult always with someone who to protect your back. All right. There's other free
One
ways of establishing title?
Absolutely. One important form of title, which we haven't talked about yet, is kind of a combination of joint tenancy and community property. It's called community property with right of survivorship.
Okay.
Okay? All this does,
Blend.
it's a blend, right? And it's relatively new in California. And all it does is it allows married couples or couples in domestic partnerships to purchase property and still receive the same benefit of a right of survivorship that joint tenancy offers.
Right. So is that picking up? Do people actually do that? Is it a really proven good concept to go with?
It is, and the reason is there are certain tax benefits to taking title as community property as opposed to joint tenancy. The IRS recognizes that form of ownership differently than it does with joint tenancy, and married couples or couples in domestic partnerships receive certain tax incentives by using that form of ownership in California as opposed to joint tenancy.
Wow. Rami, you just opened the book here. I know that we have, as realtors, we have studied the basic ones and so on. Most frequently, we didn't address the type of title where the corporation or LLC or partnership is formed and so on. But all these put together, you have really options that you can customize to your personal situation.
Right.
But you do need help, obviously, in structuring it to fit your personal needs, right? So definitely legal advice would be beneficial.
Right, legal advice is necessary. And Nick, if I can just emphasize one point with regard to taking ownership under an LLC or a corporation.
All right.
Besides being able to manage property effectively between two owners, the main benefit of taking title under an entity like a corporation or LLC is that the owner's liability is limited, meaning any liability that arises related to that property would shield the owners. It would shield their personal assets from creditors.
That's definitely a way that most investors do with their commercial properties.
Absolutely.
Almost every property that I know of is under the 100 North Brand LLC. And
Right.
we know that that is the ownership of that particular commercial property.
Right. Now, there is a cost associated with setting up an entity and taking title in that way. But for many people, the cost is minimal compared to the risk to their personal assets that they would face if they took title personally as tenants in common or joint tenants.
Yeah, I think it's obvious. I think it's the right way to go with. So you heard it all. I hope that this, as Rami said himself, rather dry issue is handled in a dramatic way and that we have learned something. So until next time, Rami, thank you.
Thank you, Nick. My pleasure.
We'll talk.
We will. Absolutely.
We'll see you all on the next Real Estate Junkies.